Well, today we're going to talk about third-party beneficiary contracts and assignments. First, third-party beneficiary contracts. And let me start with an example of a third-party beneficiary contract. Abby enters into a contract with Bill, so there's mutual promises going both ways there, with Bill, who promises to build a house for Penny and also buy all the lumber for the house from Penny's lumber store. And so basically, in this case, Abigail is the promisee and Bill is the promisor, and the third-party beneficiary is Penny Jones, and she's going to get a benefit, and she can get a right to claim the benefit separate and apart from Abigail. Of course, Abigail could always sue Bill if he didn't do as he promised. But at common law, it was a big change when they changed the law and allowed people who were intended beneficiaries to sue. So we'll see there's two kinds of intended beneficiaries: creditor and donor beneficiaries. And if you're not one of those, you're an incidental beneficiary, which means you wouldn't have any rights to the contract. Okay, so that's one case. In that case, the Penny would have a right to sue and demand the thing. Now, it's important to understand that the parties to the contract can get together and cancel the contract, and that would, of course, mean that the party wouldn't get the benefit. In the case of Penny and Abby, they're sister-in-laws, and that's why it's an intended beneficiary contract, because she intended to benefit her sister-in-law. But Abby decided to help her new sister-in-law, Jenny, out, having all the lumber to be purchased to rehab an investment house she was flipping. That is, she was going to go in and completely remodel the house in hopes of selling it for a big profit in the revitalized downtown of a major city, requiring her subcontractor Carpenter to buy all the lumber from Jenny's lumber company. Okay, so that's a kind of benefit to her, right? So it will help her business. Later, she changed her mind about Jenny when the carpenter complained about the quality of the lumber, which was causing delays in finishing. So Jenny wasn't delivering very good lumber. Now she's going to have to pay for whatever lumber has been delivered so far, but she's changed her mind. She also is none too happy with Jenny for filing for divorce of her brother. She and the carpenter rewrote the contract, modifying it and effectively terminating the unvested beneficiary interest of Jenny. So you don't have a right until it vests. That's oftentimes at the end of the contract. Sometimes if it's a creditor beneficiary, with a creditor beneficiary, it can vest early, because a creditor beneficiary, it vests when he relies upon receiving the money, and we'll talk about that in a bit. And so, general rule of privity. The reason that the common law at first did not allow a non-party to the contract, a third-party beneficiary who's a non-party, they're not really a party. They're called third-party beneficiaries because third parties are people who are not in the contract. So the common law only recognized you having a right if you were in privity of contract, meaning that you had to be a party to the contract. You had to be a person who had received a promise and were giving in exchange for that promise maybe something. So you had to be, part of that mutual exchange that we recognize as a contract. Persons who were not parties to the contracts did not acquire any rights in them. They could not compel enforcement of them, nor demand damages for non-performance of their terms. An exception was made where the third-party beneficiaries were intended by the parties to acquire the benefit, and the beneficiary's interest has vested. So there's two things there. They have to be an intended beneficiary, and their rights have to vest. So we'll talk about vesting. Vesting occurs when a beneficiary detrimentally relies on the contract's terms, or changes their position in regard to something to where they say, well, I relied upon that contract, and therefore I ought to be able to assert this right. So that's how vesting is. You know, like I said, sometimes it does it best in a donor beneficiary, as this is a donor beneficiary, right? So Penny is giving to Jenny a gift, and at any time she wants, she could change her mind. And it's kind of a continuing gift because, you know, lumber is going to be brought throughout several period of time while the house is being built, and therefore, you know, although of course once lumber has been ordered and paid for, ordered and received, you've got to pay for it. Rights of beneficiary. In contracts, the third-party beneficiary, if the beneficiary was intended to be benefit, acquires rights to the contract. To enforce he acquires the right to enforce the terms beneficial to them or receive damages. The beneficiary must, 1, intended to get that benefit, and 2, have become vested. So he's not able to assert those rights that he would have acquired until actually he has somehow changed his position. It could be, in this case, it could be she certainly changed her position when she delivered lumber. So they can't say, well, gee, we're going to return this lumber to you, and we're not going to pay for it. So the parties to the contract can't alter the contract. Now they could return it if it's actually defective enough, you know, but it would have to be defective, and they couldn't return anything that they had used, whether it was defective or not. The parties to the contract can alter the contract at any time, and third-party beneficiary rights can at such time be terminated. So the types of beneficiary, as I mentioned, creditor beneficiary. If the intention was to discharge a debt to a third party, then that third party is a creditor beneficiary. So basically, you would have that situation where you know, one of the promisors owes some money, maybe does some work for the other promisor, and of course both promisors and promisees. We talk in terms of these beneficiaries. We talk about the promisee being the person with the right to receive the payment of money here. And so this party who is owed money by the other promisor, what we call the promisee, wants that person to pay the beneficiary, or do something that benefits the beneficiary, whatever it is. So if that's the case, and in this way they'll be receiving some money. If that's the case, they are a creditor beneficiary. So as we'll see in the next example what that is like. We'll talk about a donee beneficiary. If the intention was to make a gift, then if the third party is a donee beneficiary, as the case we've talked about is, as such, his rights vest when his benefactor donor discharges his obligation. And of course, his benefactor donor remains in favor of gifting. You know, as long as the donor benefactor, he can continue to receive this benefit. Incidental beneficiary, like I said, is a party who receives an unintentional benefit. There was no intention to benefit. Maybe if they were buying Jenny's lumber not because she was somehow related to Penny, if they were buying it from Jenny because they just thought she had better lumber, or had some other quality, was closer to the work site, therefore convenient for them. If they were buying it from Jenny because of some other reason, she would be an incidental beneficiary. She's getting a benefit, but it's simply incidental to the contract itself, and she has no rights to enforce that promise, so they could easily change that anytime, and she would not have any objection to it. Why do they give these creditor beneficiaries, for that matter? In assignments we see the same thing happening. Why do these third parties acquire an interest, whether it's an assignment or a third party beneficiary? Because it protects those third parties, and so you can see the need to protect them with creditor beneficiaries, and as we'll see in assignees, you have a very similar situation. It protects those third parties should, for some reason, the promisee, the party to the contract who intended to give a benefit and intended the benefit to flow from the other party, should that party, for some reason, not be able to bring a suit to compel it, or doesn't bring a suit to compel it, then the creditor beneficiary, the donee beneficiary, could bring its own lawsuit demanding that he receive the benefit. But like I said, if both of the parties agree, as with other things in contracts, if both the parties agree, they can rescind these rights. And the only way that the beneficiary, third-party beneficiary, then could get the gift is he had to become vested, and to some extent, probably in this lumber contract, if it's been going on for a while, she's become vested to some extent, but so maybe partially vested, not vested to receive all the benefits. They don't have to continue to buy lumber from her, especially if she's returning or giving them bad lumber and they otherwise don't want to do it. It's enough that they just no longer want to do it. Okay, assignment. Assignment is different. It's the transfer of a contractual right. So in a third-party beneficiary contract, the third party's right is created by the contract itself. So it says in there that so-and-so is going to receive this benefit. Now you may have to go outside the contract to prove that this party was an intended beneficiary. It may not be stated in the terms. As long as it can be proven that there was an intent to benefit, and it's oftentimes enough to show some sort of relationship, some reason why the party would have wanted to intend it. Because it's an unusual thing to specify a certain lumber company, and although it could be done for, like I said, reasons of thinking that they have better quality or better delivery or a quicker delivery or more reliable or something like that. That could be, but it's usually not the case. An assignment is the transfer of a contractual right. Now I have to add something to that. It may or may not include an express or implied delegation. What's a delegation? A delegation is the transfer of a duty. So with some people will have assignments in which they're transferring not only a right but also a duty. So for instance, if you're leasing an apartment and for some reason you have to change cities and you can no longer stay in that apartment, no longer want to be in that lease, and you find somebody who agrees to take over the lease for you, and so you're going to give him and assign him that lease, and he's going to be obligated then, under the agreement between you and him, he is obligated to pay the landlord. Now, as far as the landlord is concerned, he doesn't have to necessarily accept an assignment where there is a delegation entailed. So he could say, he could still hold the original lessor liable, and if you really want him to not potentially sue you for unpaid rent that the S&E didn't pay, and of course you could sue the S&E for the pay. So the party is making the assignment, the leaseholder, the party who is renting the apartment, he's called the S&R, and the party who is taking over the rent and paying for the lease on the apartment, he's called the S&E. So the S&R will be held still liable to the contract oftentimes by the landlord. The landlord may well have a clause in the contract saying there can be no assignment of the lease without his approval. So he might want to keep certain parties out of leasing his apartment, as long as he's not violating some sort of discrimination statute. So he can't be violating the Equal Employment Act, or he can't be violating the Civil Rights Act of 1964. As long as he's not violating some sort of law, he has a right to refuse an assignment. However, if he puts it in the lease, he doesn't normally have to do too much in terms of asserting it. He still needs, if challenged, to be able to eliminate to provide a reason why this new tenant this new S&E is not acceptable to take over the lease, he can refuse to recognize him, and he can recognize him and take payment and not be obligated to continue. Okay, so we understand that the S&E takes over the obligation to pay the rent. However, the landlord can hold both the S&E and the S&O liable unless he agrees otherwise. So to get him to agree, you need him to sign what's called a novation. That novation can be part of the assignment, in which case you're going to have to notify him of the assignment and get him to sign it. And you might want to do that before you make the assignment and find out if he's got any objection to this person taking over the lease. Oftentimes there's no objection because the landlord figures I can do, but oftentimes he may not want to release the other party. So the novation, he can maybe object to that with some reason. And other than that, if you're making an assignment, you don't necessarily have to notify the landlord or the you don't have to notify the obligor. Okay, so we would call the party, in this case the landlord, the obligor. He's obligated to allow that party who rented the apartment to lease it and to act reasonably if that party wants to assign that lease to somebody else. He cannot stop it without giving some sort of reason, but he could write it into the contract that he wants to have the right to approve it. And so I would recommend you, if that's your case, you need to go and try to get him to approve in the first place. You may still be able to do it, but it may result in some sort of lawsuit. I had a similar situation with that, where I settled a case between two partners who were disputing the business, and it became clear that one of the partners had to buy out the others. And I told my client, I said, well, you can fight this in court, this partnership issue, if you want, or one of you could buy out the other one, and you won't wind up paying all those attorney fees that you would have to pay otherwise, because this could get quite expensive in the long run. So actually my guy wound up buying out the other party, and we immediately had him sign an assignment. Both parties signed an assignment. We had not had time to actually go and have the landlord do that because this thing was all happening very quickly. So we wanted to, while the parties were agreeable, we wanted to do it, because if you wait, then maybe somebody backs out. And then I didn't think that was going to be a good situation. And so we got it signed, and then I went and talked to the landlord, and he had a very peculiar lease. It was not written by any lawyer. He had all kinds of things in there, restrictions of all sorts, that really he couldn't have enforced. And I said, I didn't start with that. I said to him, there's been this assignment. It's in the best interest of all parties, and I think in the best interest of you to accept this assignment. My client can pay for the lease and the rent, and the parties are fighting. And if they're fighting, it endangers, it maybe would endanger the success of the business, and therefore that might mean that you don't get paid. So it's probably better for you to accept this lease on that economic reason. You have a right to object, but I don't see any reason for you to object. And in cases like this, I could tell him, because I'd looked it up, I'd researched it, I had the cases in my file brief. I had, in cases like this, I would have been able to pull out these cases where the courts had said in Ohio that the landlord in this situation where these business partners are quarreling has to accept that there needs to be an end to the quarreling, and has to accept an assignment, and it has to come up with a very good reason why he's not doing it. He has to show some reason why he thinks he's not going to get paid, and in this case that was not the case, and he immediately accepted it. So we got along famously, I thought. So it's always good if you come out of a negotiation and the other party feels that you've done the right thing by him. And this landlord thought that. I think in all the times I had to negotiate with a businessman, I was always able and ready to give him good business reasons why he should, do what I'm asking him to do. And, and it always turned out well. Now, if you're dealing with an underling, like I did as in an earlier case when I talked about my client wanting to return a car and the manager was being stubborn and not taking it, he probably didn't think he could take it. So this is the second man in charge mentality, isn't it? And you can see that in some of Shakespeare's plays, where there is a second man in charge, and he's going to act differently than, say, the top man would do in that situation, because he's used to doing things at direction. So before he would have approved taking back the car, he probably would have had to get the manager to agree that it was the right thing to do. And I told him, well, I need to talk to the manager, because I knew what was going on with him, and I just had to go over his head. So in this case, I was talking directly to the man in the first place. There was no in-between man, and it was perfect. Okay, so the transfer of the duty. If all you're doing is transferring a duty, let's say that in the first case we talked about, where somebody paints a house and the other party is obligated to pay him, and that party who is to receive payment for painting the house wants to transfer that right to receive that payment to this party that he owes money to. He could do that, and in that case it's clear, since there's no delegation of a duty entailed in that assignment, that they have to go through it. And this is simply a matter of paying money, so there's no, what objection could there be to doing that? Now, if it were actually, if the obligor had to do some service, he might object to doing the service for that person. So, that would be a personal defense, which could be asserted in an assignment, and could be asserted also with third-party beneficiaries. So you have a very similar thing going on with third-party beneficiaries, which is why oftentimes in business law texts in undergrad school, you oftentimes find these two topics conjoined and talked about at the same time, which we're doing here. So as I was saying, may or may not include an express or implied delegation of duty. So an assignment may have a delegation of duty. However, it brings up issues that may give a reason to object to the landlord or the other obligor who's obligated to do. But the obligor there is also an obligee. He's also got a right to receive something in return. And so if all it is a right to receive money, what can you object? One of the things about a landlord is a landlord has a right to believe and to be selective, and to want to have parties who are going to take good care of the house. So he could object to it. He probably might not want to give the novation, because he wants to see whether or not this new party is going to be a good tenant or not. So a good tenant is not going to be destroying your property. On the other hand, I've known tenants, especially who have occupied a house, to do all kinds of strange things. I have a friend who was renting out his parents' old home. His parents had moved to a nice home. He was a lawyer like me, and they told him to take care of this matter for him. They weren't able to sell it, but they could find these parties who were willing to rent it. The trouble was, the parties who were renting it, unbeknownst to my friend or his parents, were actually using the wood in the building, the banisters on the stairs, the lintels, the boards going across the top of the doorway. They were using those for firewood. These were people who didn't have much money. I think they were drug addicts, and they were burning up the interior of the house to keep warm. So they wrecked the house in many ways. And by the time he found out, substantial damages were done to that really nice old house, which was in a very old part of the city, but a very prestigious part of the city at one time. So the house was really one of those nice old houses that you sometimes find in cities, in large metropolitan cities, which had been prominent at one time, and that was that kind of house. And so it was really kind of heartbreaking for him and his parents to see what had happened to the house that he had grown up in and that they had owned and enjoyed all those years, and now they have to fix it. And so it really wasn't worth it to rent it. So you need to be careful when you're renting your property. If you have some reason to think that this party would damage your property, then you might want to object to it, and if you can. And of course you have to be careful not to violate any laws. Megan's Law would be an interesting case. I imagine most people wouldn't want to rent to somebody who might have been a known child pornographer, because it will drive down the property values in any neighborhood that party goes into. How you can stop them, I'm not sure you can stop them. I think that they have a right to find shelter, but oftentimes people are just using any excuse not to allow them to do so. So yes, there may be an implied delegation. Maybe that's not being written into the contract. Maybe there's no writing at all. So there may or may not be a writing. Of course, you go to a lawyer, there will probably be a writing. It's always better to get things in writing. And the landlord might insist upon some sort of writing to protect himself. And if you were the S&R, you might want also to have a writing. So in one case I knew of, this party had rented out their house that they had been unable to sell, and they had to move suddenly to Florida because of a job opportunity that the man had to work for a very nice firm with a very big boost in salary, so they wanted to take advantage of that, but they didn't want to have to pay for 2 mortgages at the same time. And they couldn't, unfortunately at the time, houses weren't selling. They could not find anybody willing to buy it, but they found a party who was willing to rent it. And the party that was willing to rent it was not destroying the interior of the home, but had chopped up the back porch, the back deck. It was a deck, which was a wooden deck that was off the kitchen. And they had taken that wooden deck and destroyed it. And you know, when they found out that that had been done, because they got reports from neighbors that it had been done, they then of course were able to eject them, just in case they decided to do more damage. You know, that already had done some damage to the house. That particular tenant was actually paying the rent. In some cases, people who do this are not paying the rent. But my friend who had that house in a very nice part of Cincinnati called Avondale, you know, my friend who had that house was, not only were they destroying the house, they were actually not paying the rent, which is why they decided to eject him, because they said, oh, they're not paying the rent. And of course that meant that they had to pay the mortgage themselves, so they got back the house in damaged condition and then had arrears and rent to be paid. And so it's not, you know, you can see that one should be somewhat choosy in accepting an assignment or creating an assignment. You know, as long as you're going to have an interest in that house and be liable for it, you need to be a little bit wary. Okay, so we talked about assignments as simple assignment. A simple assignment. You have maybe Lana, who has done some work for Xerxes, and therefore she's entitled to payment. And Xerxes, an obligee, Lana is an obligor, and you know, there is an assignment. Oh, I'm sorry, I got it backwards. Xerxes is the obligee. That means he's entitled to receive payment. And Lana is obligated. So Xerxes did some work for Lana. And so Xerxes, as an S&R, creates an assignment, and he assigns to Darius, who's the S&E, the right to receive the money. So Xerxes painted Lana's house, is owed $4,000 from her, tells Lana to pay Darius, to whom he has assigned the right to collect. Now, if of course, yeah, that's the case, all he has to do to vest, assignment also, same with other third parties, any third party, their rights have to vest. In this case, obviously, there's not any problem recognizing it, except, of course, Lana has to be notified to pay him. You know, there's no need for him to show that he's a creditor beneficiary or a donor beneficiary. In this case, he would be a creditor beneficiary, maybe, or maybe not. In any case, if Xerxes wants to require him to pay the other person, then there's no problem at all. So Xerxes, paying at Lana's house, is owed $4,000 from her, tells Lana to pay Darius, to whom he has assigned the right to collect. She can't object. Payment of money is a simple transaction. You put a check in the mail. There's nothing you need to do if you're the obligor. In this case, Lana's the obligor. If you're the obligor, you need to just go through with what you would have, instead of putting a check in and sending it to Xerxes, send it directly to Darius. And if you send it to Xerxes, he'll just be a little bit upset with you, but probably, and just send it over to Darius. But it may make a difference to Darius. He might be upset. It may delay his getting the money that he was counting on getting. And Darius will oftentimes be happy to receive payment that way. So if you got a party who's otherwise not too good about meeting his debts when they become due, an assignment is one way of getting around it. Now, a more complicated situation could arise where the obligor is a lease contract. So if the obligor had a lease contract, and you know, the obligee then makes an assignment, the S&E has a right to receive, but since it's a lease, there's an obligation that the obligee has to the obligor. So there's an obligation going both ways, and so he wants to assign the lease. Lana would be required to give that lease to Xerxes if that's the case, and you know, he can't attempt to assign it, but there could be problems if Lana doesn't approve of Darius, believes he's not creditworthy and won't pay. She may object to the assignment. In any case, she might just simply want to keep and not sign off on the assignment, or basically not sign off the novation provisions that would be attached to the assignment. Just not sign those and say, well, you can assign it to him if you want, but I'm going to still expect payment, and if he doesn't pay me, I'm going to hold you liable, which would be a very reasonable thing for most landlords to do, and so that's what they will frequently do. So, Xerxes leases Lana's house, subleases it. He wishes to transfer the lease to Darius, and asked Lana to sign and release him, and to accept Darius, to whom he has assigned the lease as a sublease here. This is an attempt at a novation. If he wants her to sign off, if he wants to agree to accept. Now, I mentioned the fact that you don't need to notify the obligor that you're assigning these rights. You don't need to notify them, and so I was able to do that with my partner, who took possession and ownership of the lease that the business was being run out of immediately upon their agreeing, and so we pretty well got that wrapped up at once. And then I sought out the obligor and got him to sign. That's sometimes the way it happens. So you don't need to notify him even. You don't need to have a writing. However, I like to have a writing, but you don't need to have that writing signed ahead of time. You can get it signed subsequently. And they really, like I said, will usually, even if they have a provision saying that they're not going to recognize a assignment, private parties, except for banks, pretty well do need to recognize that in certain situations an assignment makes eminent sense, and they have to be reasonable and act in good faith and cooperate if in fact asked to take payment from somebody. Now, it might be unreasonable to demand that they actually limit themselves to them, and it might be unreasonable if they have some reason to believe the party will do damage to property that they have that is going to be, in this case, leased out. This is an attempt at innovation, though, and so a lot of people would want to get that, and can't always get that, can you? Most apartments are leased that way. Houses, I believe, too. Assignability of contract rights. Assignable without notice to or even consent of the obligor. So I've got that in the PowerPoint here. The assignment can be assigned without a writing or signature of the S&R. If you don't have a writing, you can't have a signature, right? And obviously the assignment, if you do have a writing, you have to put in all the required things, but if you don't, it's not fatal because you can't have an assignment without a writing. So the fact that you forgot to put a term in there, it's bad from the sense of the parole evidence rule, you remember, but it's not bad from the existence of the contract. With some contracts, if you mess up and don't include certain terms, the court may say, hey, I don't see where you have a contract here. Because, if it's required to be in writing by the statute of frauds, you need to get it in writing statute of frauds. But if the assignment is not required to be in writing by a statute of frauds, is not required maybe to be in writing by a clause in the contract that says that any assignment must be made in writing, if there's no requirement that it be in writing either in statute or in the contract that is being assigned itself, if there isn't that provision in there, you can just go ahead and make the assignment. And the fact that the written assignment was in some ways defective in describing the terms of the lease is only going to affect you in terms of what you can prove it, those terms to be. In other words, you want to have that writing say everything because you want to be able to use the parole evidence rule so that there's not going to be some sort of dragged out court case where you're going to be running up attorney fees and maybe you win or maybe you lose, and that's the worst case scenario if you lose. So yeah, by all means try to get it written right up, and also make sure that all the terms are included in there. But you understand that you don't necessarily need a writing to have a valid assignment. Okay? So modification, oftentimes what we're talking about is modification of an existing contract. That's what we talked about in terms of the lease. The lease already exists, so there already was a contract. You're just transferring that lease on this assignment. So assignments are a transfer of a contractual right that existed in common law. We're going to also be talking a little bit, not maybe too much right away, about the negotiation of things that are commercial paper, where the rights that are acquired by the party taking the transferee may have rights, but to do that they have to take a negotiable instrument by a process of negotiation. They have to qualify as a holder in due course, which I don't know if we'll be able to get into all that tonight, at least probably not, or whether we'll get into that at all. But the obligor with knowledge of the assignment has the right to enforce the terms of the contract against either the S&R or S&E. So he has a right to demand payment of any rent monies, right to pay any fees that he may be charging because the party has a pet in the apartment or house, and there's a clause in the contract saying that you have to pay a fee if you're going to have an animal in the house. I think that's very important. If I were a landlord, when I was looking for houses, I've been in houses where there was stink of an animal. They had pets, and those pets were basically peeing on the wooden floors, peeing on the rug. And so after you buy the house, you're going to have to actually, unless you want to live with that smell, you will maybe have to remove the rug, remove the floorboards, just to bring the house up to what would have been a saleable condition, and so you may not want to do that. Obviously, when you're buying a house that's in that kind of condition, you would be wanting to get a lower price. So if you're renting your house, you be very careful in terms of if you're renting it to somebody who has a pet. You know, are you sure they'll be able? You know, you might want to extract a promise that they'll be keeping their dog outside, or that their dog is house trained. Even a house trained dog, though, could have some sort of medical issue. Where I had a client once who came in, her dog developed a problem and was basically shitting. You know, and it was a medical issue. She wound up taking him to the vet, who did fix the issue, but in the meantime, the rugs in the apartment where she was living got spoiled, and the landlord, when she left, had to remove all those rugs and replace them. And, you know, don't always have to do that as a landlord. And he noticed the smell, and so he objected to that. So that was unfortunate for her. Luckily, though, for her, I was able to defeat him by getting a, he thought that the smell was from urine, that the dog had peed in the apartment. So he says, well, the dog's peed in the apartment. That's not the case. It was worse. and he didn't know that. So I contacted the veterinarian where she'd gone and got a statement from him that the dog did not have a problem with the urinary tract, an affidavit. And since this was in small claims court, the evidentiary requirements are less, and so I was able to introduce that as evidence, and he didn't know what to do about that. He never challenged that. You know, obviously, he should have wanted a postponement and contacted the vet to find out what the case was. But since he was going into small claims court without a lawyer, my client had retained me and was paying me. She got the benefit. So going into small claims court, you can do it without a lawyer, but to some extent it might be like going to a gunfight without a gun. So that's an old saying. In a lawsuit, you need to have a lawyer because it's a specialized field. Now you might say, well, that shouldn't be the case. We shouldn't have to hire lawyers. Well, each side is entitled to a lawyer. If the other side has a lawyer, you may well want to have a lawyer. And if you're suing a big corporation, it usually means you need to get a lawyer. That's why sometimes we have statutes allowing lawyers to collect their fees from a businessman who has done something wrong, but he has to win the case to get that. So basically, he's not going to use it to harass businessmen. The worst he'll do is maybe write letters, but he won't take it to court if he doesn't think he can prove it. If the case is not a good case, if the client doesn't really have a good case, a solid case, where they have a right to receive payment, where the merchant was wrong, then that's when you can win the case. So that's why when I talked about warranties and I went and represented the fellow with the car, with that, I wanted to talk to them and get them to agree to do it, because I didn't want to go into court with it, although I believed I could win. And also it gave me leverage. I was not at the time thinking about making money in the practice of law. I was actually teaching here at Ball State at the time, and I was traveling to this Cincinnati, far away, to do this case. I wanted to get the case over with, and I wasn't interested in making more money, so I was able to tell him all the reason why he shouldn't fight us on this, because it's only going to be making more money for me, although frankly I didn't want the case. I didn't want to earn that money that way. I was too busy in those early days preparing my lectures. Okay, the obligor, the assignment can be assigned without a writing or signature of the S&O, except where the written contract requires modification of the contract to be in writing. So that would be a clause in the contract itself, an express clause. You'll need to look for that. You could argue that it was left out, but then you're going to have to find an exception to the parole evidence rule. So that should be in the contract. Or the statute of, or a statute, doesn't have to be the statute of frauds. The statute of frauds could require writing. There could be other statutes that might require in certain kinds of contracts for there to be a writing. It depends on the state whether they want to, the state has the authority to require anything to be in writing that it wants to be in writing when it comes to these contracts. So the obligor with knowledge of the assignment has a right to enforce the terms of the contract against either the S&R or the S&E. They usually keep that right, which if they're my client, I would tell them that's the right thing to do. But you can't stop them from doing the assignment. And there's no problem as long as the S&E makes the payments, if that's all he's required to do, and doesn't, wreck the house or cause damage, or, doesn't do anything that's causing trouble, not throwing big parties and getting all the apartment dwellers in the place upset to where the landlord wants to eject him. He'll eject him, and he'll still want the party who is the S&R to then step in and pay the lease, or find somebody else to step in and start paying the lease. So the obligor, with knowledge of the assignment, has a right to enforce the terms of the contract against either the S&R or assignee, and that includes things like collecting the pet fees. Yes, the S&E maybe didn't sign the lease. The landlord could ask him to sign the lease, but even if he hasn't signed the lease, he's still, as an S&E, required to obey the terms of the lease, and that means, behaving reasonably, as all apartment dwellers are required to do so. Okay, so the S&R can be relieved of liability under a contract by a valid release or an novation. You can call it a release, so there would be language that talks about a release in the assignment, but you need to get the obligor, the landlord, in the case we talked about, to sign that novation. Novation, of course, is the substitution of a party. So you're substituting the S&E for the S&R with the novation. You're not required to do that, although you're required to allow them to make the assignment. That since there's a delegation of a duty, you have a right to expect that the party doing the assignment, the S&R, will actually still honor his commitment, his promise to pay the money when due, and will, not expect him to pay as long as the tenant is paying, as long as the new S&E pays. Usually there's no problem with that. He's not going to be stupid and try to collect money twice. You can't do that at law. S&R can be relieved under liability only by a valid novation. A written assignment may incorporate a release of the S&R, but it then would have to be accepted. By that I mean it has to be signed. So you can see a contract saying, well, subject to the acceptance of the obligor. I mean, basically, you could, if you were wanting to insist that the assignment is not going to take place unless the obligor will actually agree to take that. Why would the obligor agree to that? Well, if this party, let's say the party is leaving the country, and it might be difficult to actually collect from him. You'll have to, you can, in most countries, you would probably be able to sue him overseas for that, but you're talking about additional expenses in terms of legal fees. And in this country, in most cases, one is required to pay one's own legal fees, with the exception being only for cases where because consumers are being protected by a statute. So assignability of contract rights, they're very much freely assignable. So the law favors the assignment. Assignment of rights. Generally, a party is ordinarily entitled to assign his or her rights to payments under a contract to a third party without discharging the other party's duty to perform. Exceptions. In the cases where the assignment is prohibited by a term of the contract, if reasonable, the obligor could block the transfer. He can't, but he has to have a reason. Like I said, there's something about this particular S&E that's objectionable. Also, where the assignment includes a delegation of duties to a party which the obligor could object to as creating unreasonable risk or insecurity of performance. So the last several apartments that I've rented, I can't remember renting an apartment where they didn't actually check my credit rating before they allowed me to rent from them. And because I had a very good credit rating, the last several times I actually rented an apartment, I didn't have to pay a down payment. I didn't have to give them an earnest money deposit. They said, well, you've got a good credit rating, and they didn't require me to do that. So these are just things that you learn as you go along. Of course, they could require that, and I probably would have paid, because I went to all the trouble of searching for a place. You pick a place and you'll probably just, you have an idea of paying a deposit, which you expect to get back when you leave. It's not such a big deal. Also, where the assignment includes a delegation of duties to a party which the obligor could object to, well, I already said that, then the obligor could object and block the assignment, even absent a prohibitory clause in the lease. I actually have a mistake here. It says prohibitory assignment clause. Oh, well, what I meant by that was a prohibitory assignment clause that is in the lease or in the contract that's being assigned. I'm not talking about the assignment contract yet. The assignment clause is a clause that's in the contract being assigned, saying there can be no transfer of the rights and no assignment of these rights to a third party. Professional contracts. When you hire a doctor, lawyer, or other professional, an accountant, maybe, or another professional, you usually will be required to sign a contract. These parties almost always have some sort of contractor. They're going to be doing professional services for you. They don't want to do work for you and then you refuse to pay and they have to sue you. Even the lawyers don't want to do that. Usually these things are taken care of up front, which is probably the best thing to do, get people to sign that they're going to pay. Sometimes maybe you'll have them pay a down payment depending upon their credit ratings. So if a party wants to hire a lawyer but he has a bad credit rating, he may actually in some cases be required to pay the entire amount of the representation up front, the expected money, and then be liable if there are additional monies to pay because of something that was not anticipated. For instance, an appeal. Usually when you bring a lawsuit, you don't anticipate having to appeal the case. You anticipate winning the case, right? Well, if the lawyer's going to do the appeal, if you want him to continue in representing you and do the appeal, usually he's maybe going to charge you extra money for doing the appeal. So that's a separate kind of thing. And of course, you could also change if you want and get a different party to do it. But he already knows the record in the brief, so he can do it more quickly and maybe more efficiently, provided, of course, he is competent. And as long as you have faith in him, probably you're going to stick with him. Anyway, the contract now, it's interesting. There's been a number of cases I've heard of where a doctor had agreed to do an operation for a person, and you sign with the doctor, and what you're signing is for his firm to do it. And so somebody else winds up doing the operation. The doctor may or may not even be there. He may be there kind of overseeing, or he may not even go if he got complete confidence in the party he turned it over. And so maybe you've got a doctor who comes highly recommended, and you later find out that he wasn't the one who actually did the operation, but somebody who works in his firm, perhaps under him, or a co-partner, or a partner, or an associate, actually did the operation. He's responsible to make sure that that party is licensed and competent. And he is responsible if there's a malpractice. So both he and the party committing the malpractice would be liable. But you don't necessarily get that. So you go out and you hire F. Lee Bailey, a famous defense lawyer, to represent you in a case, and you realize as the case is going on that he hardly is showing up. He comes in once or twice, but for most of the hearings, somebody else is there representing you. And you thought you were getting this top, well-known, famous litigator, but you're not. You're getting somebody that he says is equally competent and able to do the case. Because that's the contract you sign. So you always want to read your contract and understand what it is that you're signing. The contract specifies that you are hiring the services of his firm. Therefore, that enables him to actually bring in some other person to actually work on you or work on your case, whatever, work on your books, whatever the professional is doing for you. If he or she assigns another member of the firm to work on your case, you cannot object. The contract was between you and the lawyer's firm, or the doctor's firm, or the accountant's firm. Okay, Tommy and Stan's case. This is a little bit complicated case. It's going to take quite a while. I don't know if we have time to go very, okay. We do. Tommy had agreed to invest $22,000 in Stan's new Syrian restaurant, becoming Stan's partner in an unrecorded oral agreement. They later became embroiled in a dispute over managed control. That is, Stan claimed to have 60% control, Tommy claimed 50-50. Under partnership law, in an unwritten agreement, which is what they had, you can also have an unwritten agreement in a partnership. Tommy is right. They're 50-50. If they testify differently, Tommy's going to win because he's saying 50-50, which if you don't have a written contract and the parties dispute that term, it's in statute that the court will find that they're 50-50. They're equally entitled to manage the partnership. They're also equally entitled to receive whatever money. So if you want to have these things different than 50-50, you need to have a written contract. That's a mistake on this. Under partnership law and an unwritten agreement, Tommy's right. However, Stan's lawyer has an ace to play in the statute of frauds. Still, so we talked about this when we talked about this case when we were talking about statute of frauds. Still, there was a trial court decision in a rare, little-known exception to the statute in Ohio where this case took place, and a possible written tax filing representing the business as a partnership. So I had reason to believe, since that was my case, that we could overcome the statute of frauds either one way or the other. And I was able to get in what I thought were important moral arguments that I believe will impact any judge. If a judge thinks something's not right, he's more likely to go for your case even in a weak case. So a precedent that involves a trial court recognizing an exception to the statute of frauds that doesn't exist in the statute itself, that's a weak case. I didn't have much choice. I could have not shown up at the injunction hearing which we were at, but then he was surely lost, and I thought that would not be a good thing to do. So I went in, and I was able to come out on top, and then I had them agree to the assignment. Because the next thing, now you say, well, what does this got to do with assignments? Well, the next thing, after we settled a case between the partners, because there had been a lease entered into by Stan. Stan had entered into a lease. Now, Tommy was buying out Stan, so Stan was going to make an assignment to Tommy, which we had a writing for him doing that, and we got that signed. We had a place in there for the landlord to sign it, but me and the attorney for the other side knew that I could do that after the fact. So we had them sign it, and I went out within a couple of days and talked to the landlord. And he, again, like I said, when I've had good luck in negotiating with owners of businesses, because when I never go in with something that's silly. I'm never trying to take advantage of them. I always have an argument that this is better for them than the alternative. And then, yes, the alternative in this case is he's got these two parties who are obligated to pay him. So that looks like an advantage. But if they're fighting, then that might cause the business to suffer. And if the business suffers, then he may not get paid. And so if my client has got a good credit rating and has the money, to show that he'll be able to make the payments even if the business doesn't do well, what reason does he have to object to the transfer of the lease where there's an obligation to pay? He doesn't have one, and he did have in his contract a no assignment of lease without his approval, but I thought it was never going to be any issue, and I thought I could persuade him to do what was reasonable, and I did. I mean, they're basically interested in getting their money, and if they can see that this is the best way forward, they'll oftentimes take the best way, even and not stand upon their rights. Any good businessman is not interested so much on asserting rights as he is in making money, right? Okay. So, having survived the injunction, Tommy decided to buy out Stan to avoid a possible appeal and the cost of further litigation. An agreement was reached. Stan and Tommy signed an assignment agreement giving Tommy sole ownership of the partnership, also assigning him the sole rights of tenancy under the lease, leaving one last matter to deal with. Tommy's interest in the property arose upon his becoming a partner. Hence, he needed an assignment. He needs this assignment for future references somebody else, if he wanted to sell the business or he wants to go to get a loan, he'll need to show how that he's a businessman who minds the P's and Q's. He needs to lease, and for tax reasons and other reasons, he should take care of business the right way. Tommy's lawyer would have to get him to sign. He had the case law which he believed could be used to compel the landlord to sign. So I had in my briefcase actual cases that I'd copied that if the landlord had objected, I could show him, or I could compel him to do it because it was reasonable in light of the situation. In other cases where businesses, where there was a breakup of the partnership and there needed to be an assignment, businesses had been compelled, the landlords had been compelled to actually recognize these assignments, even though they had a written right, express right in the contract to object. They object, but it doesn't stand up. Whoops. Back. Transfer and delegation. Assignment, just to review these things, assignment is a transfer of contractual right to a third party. Assignment is effective in most cases, especially if we're talking about an assignment of the right to receive money that has been earned. The S&E acquires all rights that had vested in the S&R and no more. I mean, if the painter had only done half the job and there was still another half of the job to be done, then the only money that S&E can receive is money for payment of what was done up to that point, and maybe not even that if the contract says that there's no payments to be made until the job is finished, which is what I always put in my contracts when I hire somebody to do remodeling on my houses. They have to finish the job to my satisfaction, and that means that it has to be a good job done well, and they understand that at the very beginning. I'm only going to pay, and if there's some reason I can object to it, I will object to it, and maybe we'll negotiate a lower payment for what work was worthwhile, and that which wasn't worthwhile, where I'm going to have to maybe have it repainted, I'll be able to pay for it. Okay. Negotiation is a transfer of a contractual right to a third party by means of a negotiable instrument. The instrument must meet the requirements of negotiability. If the transferor also qualifies as a holder in due course, he will take the instrument free of all contractual defenses. Delegation transfers a contractual duty. So there's a difference between assignment and transfer of rights. On the last PowerPoint we go into that. No writing required, no document required on the assignment. Rights transfer is subject to all manner of contractual defenses, personal defenses. The S&E's rights are no greater than the S&R. And with negotiation of a commercial paper, a signed agreement, that a promissory note, a signed writing requires to have that negotiable instrument, to have a document that qualifies as a negotiable instrument, meaning it meets certain requirements in the statute. We won't go into that. If transferee qualifies as a holder in due course, then he is only subject to real defenses. So he takes free of personal contractual defenses. There are defenses that can be asserted against him, but there are a lot of defenses that he's not subject to. He has a right to receive payment. So you can transfer a promissory note much more easily. It's much like, almost like cash. And the holder in due course rights are greater, that is, they are conditional. They are unconditional, rather. They're unconditional rights. Okay, now there are questions at the end, 5 questions. You'll be getting the PowerPoint so you can take a look at those. I'm not going to go through them today because we're out of time.